En décembre 2011, la Première Nation de Kattawapiskak, représentée par la chef et le conseil de bande, déposait une demande d'injonction pour faire obstacle à la gestion par une tierce personne à Kattawapiskak. La cour a rejeté la demande, mais le juge Michael Phelan a établi qu'une requête distincte en révision visant à mettre fin à la nomination serait entendue dans les prochains mois. Le 5 avril 2012, le ministère des Affaires autochtones a annoncé qu'il mettait fin au mandat du séquestre administrateur à Kattawapiskak à compter du 19 avril, soit 5 jours avant la date prévue pour l'audience de la requête en révision. Le ministère a ensuite présenté une demande de rejet, estimant la requête dépourvue de portée pratique. L'audience se tient aujourd'hui, le 24 avril 2012.
Special sitting in the Federal Court at Toronto is now open. The Honorable Justice Phelan presiding. The court calls file T-203711 between Kattawapiskak First Nation and Her Majesty the Queen. Ms. Catherine Hensel, Mr. Benjamin Van Neuhaus for the applicants, Ms. Maria Golares, Mr. Benjamin Cates for the applicants, Mr. Gary Penner and Mr. Michael Beggs for the respondent.
Good morning.
Good morning.
Thank you, my lord. Critically important in all of this is what is the nature of the application before you that we now say is moot. I think it would be difficult for my friends to refute that with the withdrawal of the appointment, there is no role for the court to play with respect to that aspect of the relief sought. There's no appointment to set aside. So in my submission, clearly that's moot. They're also seeking a declaration that the decision to appoint the third-party manager was outside the minister's authority, unreasonable, and of no force and effect. In our view, neither type of remedy, setting aside or the declaratory relief, can be given any practical effect in light of the fact that there's no longer a third-party manager in place.
But what about the declaration of right available to a member of the public to have the court say whether or not a government act or whatever was legal, what their rights were? Isn't that at least a valid thing to request?
You know, the court does have discretion to hear a case that's even otherwise moot in certain circumstances, but then there's very specific criteria that has to be met. So in our submissions, and I will get to that, this case doesn't meet that criteria. This case is a very fact-specific case. It was an appointment of a third-party manager pursuant to a very particular agreement, which, although to some extent is generic, there are many agreements like it. The actual appointment of a third-party manager is very fact-specific to the particular situation. And so this case doesn't have such an overarching principle. My friends will argue otherwise. I appreciate it.
But isn't there a problem generally in appointments of managers or some of these kinds of things where the timeline is relatively short? If the person opposing it isn't successful on an injunction, and that's a tough test on injunctions, then as long as the appointment is pulled sometime before you show up in court, the matter dies. And the person who considers themselves offended by the appointment never gets recourse, never gets the court to say that wasn't proper.
Yes, that's right, and my friends certainly have expressed that view in their response to our motion. But the authorities for this address that problem. And they say it doesn't matter at what point it becomes moot. If it becomes moot and there's no longer any practical effect that a court determination can possibly have, then the court will find mootness. Pursuing a moot application for the purpose of restoring one's reputation is not a sufficient basis for the exercise of discretion. The evidence in this case, and certainly the evidence of Chief Spence, is that she was deeply offended by the appointment of the third-party manager. She may well have felt that that was damaging of her reputation. it may well have been damaging of her reputation, but in any event, that in and of itself isn't sufficient for this court to exercise its discretion and consider this case to be such an exception that it falls outside of what the authorities say is appropriate.
The appointment of the third-party manager you have in the record before you on the application, and you see referred to in our written submissions, has had consequences and continues to have consequences for Kattawapiskak. They're very concrete consequences. Under the third-party management agreement and the comprehensive funding agreement, any monies up to the withdrawal of the manager, not his appointment, it's third-party management that was withdrawn, not his appointment. So he will, as long as BDO Dunwoody continues to administer any monies under that agreement, Kattawapiskak will continue to pay fees. Secondly, with respect to those fees, they are sizable, particularly for a First Nation in Kattawapiskak's circumstances. Since December 5th, BDO Dunwoody has presumably, although Kattawapiskak hasn't had an accounting of these fees, has been collecting money that would otherwise flow to Kattawapiskak at a rate of $1,300 per day, at least, if it's only Mr. Marion. Thirdly, there were allegations made in the House of Commons in Parliament by Prime Minister Harper and others that the appointment of the third-party manager was due to, quote, management problems that had to be fixed by the third-party manager. Having reviewed the record, as I trust you have, on the entire application, Canada is not pointing to any management problems as justification, as the real justification for appointing the third-party manager. So these statements were untrue, and they continue to have an impact on Kattawapiskak. Kattawapiskak is a community that, like virtually all First Nations, has had a terrible and traumatic experience through Canada's imposition of unilateral decision-making, and that is through residential school. It is a community full of residential school survivors. And the community is more than offended by the decision to impose third-party management. The community is traumatized.
Does this case raise the issue of the honor of the Crown and the notions of reconciliation? Because if somebody has been offended by what's been done, doesn't that have an impact on the very notions of honor and reconciliation?
The honor of the Crown, in my reading of the case law, is always engaged.
Is always engaged.
So, that's not an issue. All we say that's relevant to the matter before you is that you're not here to presume the dishonor of the Crown. What you're here to do is to determine whether the decision to appoint a third-party manager was appropriate in all of the circumstances.
Okay. Thank you. We'll adjourn till 2 o'clock. I'll give you my ruling then.
Order.
La chef Theresa Spence a bien du courage de relever un tel défi, en risquant que la requête soit rejetée avant même d'avoir été entendue.
That really bothers me, that part. They did their due diligence. They developed a 20-year housing and infrastructure plan that would see them get out of their housing situation over a period of time, their infrastructure, addition to reserves, all of those things. Back in December, they submitted to the minister, right?
Yeah.
And I think the minister had an opportunity to say, look, we can't deal with all of this 20-year plan right now, but we can take certain elements of it and work with you to deal with the urgent things. He didn't even do that, didn't even acknowledge it or write you back, say, we got it, thank you, let's meet. They did their part.
Even with this, after this court, I don't think the relationship is going to improve. It's going to get worse because we took them to court, they're going to be on a blacklist for everything, or even.
I hope not. That shouldn't be. You know, we get into fights and arguments and disagreements.
Yeah.
Does that mean you're not going to deal with that with you at Kattawapiskak? The government will no longer deal with you now.
Even for the contribution funding, it's their ways. It's not even our ways. Like there's no time to negotiate. Like take it or leave it. That's the way it is. Yeah. And we can't do it alone. We need the national chief and grand chief and land chief, like, you know. You gotta lead the way and really be aggressive and really tell them enough is enough.
Canadians can help, remind the government that they've got treaty responsibilities that they're completely absent on. And it shows up here in the courtroom, with the tactics that the lawyers are bringing out. Tactics of diversion and avoidance and, clouding the issues and muddying the waters. And it's time to get to the heart of the matter, especially, for the people right now that are suffering. That's where all of our hearts are. So I'm glad to be here with you and see that the strong stand that you're taking, it is national. Yeah, make no mistake. I know they were talking about that in the courtroom. And I can't imagine how difficult it keeps being for you guys as chief and council every step of the way.
I've been living in that shelter for 3 years and 4 months. I could have probably asked for a housing, but my people live in frame tents, sheds, and overcrowding. And I'm a band councillor. I'm responsible for 100 people. And if it's not right for me to live in a house if they don't have adequate housing.
It's time for a change, really.
Oh, good.
Thanks.
Yeah, we'll have an hour.
Appreciate you coming.
11 o'clock.
It's awesome.
11, yeah.
Order.
Thank you. Despite the forceful arguments of Mr. Penner, I'm not persuaded that this judicial review should be dismissed on the grounds of mootness. This case meets tests in Borowski. I am satisfied that there is a live controversy, which at minimum may affect rights under the third-party management administration or in some way in the future. There appears to be significant legal issues to determine which could affect rights and relationships of the parties, and therefore we will continue with a hearing of this judicial review.
Good afternoon, my lord. I'm going to be taking you through the evidentiary record. Mr. Van Nieuwenhuis is going to be focusing his efforts on the legal submissions and characterizations of the cases. You have in Volume 1 of the record evidence that we have reviewed with you that inadequacy of infrastructure and resources generally meant that the community and its leadership moved from crisis to crisis over the last 10 years, focusing and redirecting resources to avoid the very worst outcomes and the loss of human life. This, in turn, had a very negative impact on the First Nations finances, undersourced as they were. Conditions were such that in the fall of 2011, Chief and Council made the decision that they were obligated to seek outside assistance with respect to the state of housing in Kattawapiskak, which they did. Initially, through enlisting the resources and support of the Mushkegowuk Tribal Council, who, on October 28th, on behalf of all the Mushkegowuk Cree, declared a state of emergency. I'm going to take you again on November 23rd to Exhibit Q to Mr. Hallman's affidavit. It's a letter from Joanne Wilkinson to Chief Spence.
Sorry.
Raises no issues or concerns beyond confirming the allocation of $350,000. I should just note something editorially. This is a week before third-party management is imposed, and there is no discussion amongst the parties of any default under the CFA. or any issues or concerns with the First Nations handling of the housing crisis.
Although the department is generally aware that there are problems with housing on reserves, particularly in remote areas, this was the first indication of an emergency with respect to 5 families living in tents at Kattawapiskak. On November 2nd.
When departmental officials went to Kattawapiskak, did they not see tents? Did they not see housing? Some of the pictures are in the evidence. Did they have no knowledge of the health and safety problems that the doctors have given evidence in this file? Did none of this come to the attention of departmental officials?
It did not. The evidence is it did not. The department relies on the First Nation. It also relies on the Tribal Council to provide it the necessary information that it needs with respect to what the concerns of the community are. And so in that context, maybe issuing a declaration of emergency is the appropriate way to get the department's attention. I mean, you can imagine if there were people there, the evidence is there were officials there throughout 2011, and that somebody there in July who's there for whatever reason, not to inspect housing, notices that there's 3 or 4 or 5 tents. That official may or may not ask a question about it, may not have any concerns, may have some concerns. Obviously, at 50 below to 0, if a departmental official saw an infant coming outside of a tent with no clothes on, that official would say, hey, I've got to report back to my superiors. There's no evidence that any of this happened.
My Lord, you drew the analogy in January, and Mr. Penner raised it again today, of between the CFA and a mortgage. I would point out that in the context of a private market, parties to a mortgage have a number of different options. They can choose not to buy a home. They can rent. They can live with their parents. They can buy a smaller, cheaper house. They can move to a different housing market. They can go to a different lender and negotiate the terms of the mortgage. The people of Kattawapiskak have one option. They have to sign the CFA. The other 3 options that they could have are unacceptable to them. The first is to stay in their village with no government services, and they would surely perish under those conditions. The second is to leave their traditional territory to move to the cities, in which case they would cease to exist as a people. And the third is to revert to their traditional lifestyle and economy, which I should note they're capable of doing. However, if they were going to do that, they would require the exclusive possession of their traditional territories. That would be inconsistent with the treaty. So we haven't put treaty at issue here, but it is at play.
Thank you very much. I appreciate the excellent work of council on both sides. You've tried to steer me in one direction or the other. Hopefully, one of them is the right direction. That's my burden. Thank you very much for at least trying to alleviate some of it. Thank you.
Order.
Le 1er août 2012, le juge Phelan a conclu que la décision du gouvernement de nommer un séquestre administrateur était contraire à la loi et déraisonnable, compte tenu de toutes les circonstances de l'affaire.